sit down. This is not your courtroom. Sit in that chair.
The indemnity bond, and I'm going to require the other bonds.
Take her down to the jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest. You are violating your oath, Mr. Iarochi.
Court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She is in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR like 0800 something. And
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed that.
Well, your documentation that you file, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds.
At this point, the issue is no longer the traffic charges. The court has an outstanding warrant for failure to appear, and the judge is trying to determine why that warrant should not be enforced. Demands for bonds or sovereign-style filings have no legal effect in a municipal court. When a defendant refuses to answer direct questions and disrupts proceedings, the court's authority to execute the warrant becomes immediate.
Please, for the record, let it be known that you exited.
I did. I exited the courtroom and asked the police officer and probation officer to come present.
Where is the bill of particulars?
The bond is the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to the jail now.
Why am I being arrested?
Take her down to the jail now.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest. No, this is a false arrest. This is kidnapping. They're violating my rights, my constitutional rights. I put in...
I thought the Constitution didn't apply to you.
The applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
I'll take your side.
What am I being arrested for? What am I being arrested for?
This hearing illustrates how the court system responds to sovereign citizen-style arguments when an active warrant is in play. The underlying charges were minor traffic offenses, but the case escalated after the defendant failed to appear for a properly noticed bench trial. That failure triggered a lawful arrest warrant, which remained valid until resolved by the court. When the defendant appeared more than a month later, the court's task was limited and procedural: determine the reason for the failure to appear and decide whether the warrant should be lifted or enforced. Instead of answering that question, the defendant attempted to derail the proceeding by demanding indemnity bonds, questioning authority, and refusing to comply with basic courtroom instructions, tactics commonly associated with sovereign citizen ideology. Municipal courts are not required to litigate jurisdictional theories or pseudo-legal claims during an enforcement hearing. Judicial authority is established by statute, not by a defendant's consent. Once the defendant refused to sit, answer direct questions, or comply with courtroom orders, the judge's discretion narrowed significantly. At that point, the warrant was no longer a matter of debate. Continued disruption left the court with a single lawful option: execution. The defendant was taken into custody, demonstrating a core principle of the legal system. Ideology does not override procedure, and court orders are enforced through compliance or consequence.